we bring you a talk on India's new labour codes. This talk was a part of a webinar conducted by the Department of Justice.
Around 44 central acts in the country, 29 of them were subsumed and made into 4 labour codes. 12 acts got repealed because they were very old and not relevant to the present context. 3 acts have been retained which are of a very specific nature, so that have not been subsumed with the 4 labour codes. These codes were enacted by the Parliament in 2019 and 20. Wage code was in 2019, and the rest 3 codes, Code on Social Security, Industrial Relations Code, and the Code on Occupational Safety, Health and Working Conditions Code, that was also enacted in 2020. But these codes got implemented on 21st November. These are the overviews. 2019 Code on Wages were enacted that consolidated 4 acts. This code has the provision of uniform definition of wages, universal minimum wages, and timely payment of wages. Wages related acts have been subsumed here and accordingly updated. Similarly, the Code on Industrial Relations consolidates 3 acts. This simplifies the dispute resolution. This promotes industrial harmony and improves business environment. And the third is the OSH or OSH code or OSH Working Conditions Code 2020 that consolidates the maximum 13 number of acts which is related to the welfare and working conditions of the workers. The fourth is Social Security Code 2020 that consolidates 9 acts, and this is related to the social security provisions of the workers. And this code has the vision of providing universal social security coverage to all types of workers in the organized sector, workers in the unorganized sector, as well as the new types of workforce that is emerging in the country, the gig and platform workers. As far as sections are concerned, this number of sections in the codes in comparison to the previous acts have been reduced by 61%. Rules reduced by 75%, forms by 60%, and registers by 90%, which is quite relevant for the industries, for employers, as far as the age of doing business is concerned. Similarly, returns, registration and license, these were multiple as per the previous acts, which have been made single and made digitized. There are 3 important provisions in the present context which have been introduced in the code, that is decriminalization, compounding of offences, and improvement notice. Now, under the previous act, there are 87 such provisions which attracted imprisonment. In fact, there are very small or minimal nature of non-compliance that also attracted imprisonment. For example, the factory has not been whitewashed properly. That also was in the rules of some of the states. That also was attracting imprisonment. So what has been done in the courts is the entire penalty or imprisonment provisions have been rationalized. Somewhere even the financial penalty has been considerably increased as a deterrence for second or repeat offence. At the same time, wherever the offences are very serious or grave, imprisonment provisions have also been given. So it has been rationalized, reduced. So there are only 22 provisions where it attracts imprisonment provisions under the courts, but out of that, 16 are compoundable. So only 6 such provisions are there which cannot, because those are related to very serious offences like life and death of the workers, social security related matters. Those cannot be compounded. So that is one kind of rationalized reform, I must say, in the labour codes. Similarly, compounding of offences was not there. That has been provided. Compounding officer will be notified by the appropriate government, and the affected party can approach the compounding officer for compounding of the offences for their non-compliance. Similarly, improvement notice. Previously, that was not there. If there is a non-compliance notice in an establishment, either penalty or imprisonment directly was ensured. But now, the establishments will be given improvement notice to comply to the provisions. If I go to the key features of the labour codes, as I said in the beginning, there are uniform definitions across the codes. The definition of wage, employee, workers have been rationalized. It is uniform now. One of the most important feature of the labour codes is the transparency in enforcement. Now the inspector will be called as inspector cum facilitators. And second, the inspection system entirely also being actually digitized. It will become web-based and it will be randomized. There will be risk matrix based on the risk profile of the organizations or establishments, and system will decide where to conduct the inspection. There are similarly very progressive provisions in the labor codes which will ensure higher female labor force participation.
Introducing the Tele-law Citizen mobile app for the Indian citizens. This app has been specially developed for you as a citizen by the Department of Justice, Government of India in collaboration with CSC. Through this mobile app, you as an applicant can get free legal advice and assistance from professional panel lawyers of the country in all kinds of disputed matters. Download the Tele-law Citizen mobile app today.
Now under the codes, women are allowed to work in all types of work, all types of establishment, also during night time, subject to their consent, and the employers have to ensure their safety and transport. Crèche facilities will be provided in the establishment having 50 or more employees. Now here the employees word has been made gender neutral. It includes men, women and transgender. In case there is an establishment of 50 employees and only one woman worker is there, still the crèche facility has to be provided, and this includes ministries also, government establishment also. So there are adequate and proportionate representation of women in boards. In such boards, the women workers have to have their adequate and proportional representation. Provisions in the labor codes. As I said, universalization of wage security. Previously, the minimum wages were fixed by the central government in very few selected sectors. Now the minimum wages have to be universal. It has to be applicable to all the sectors, that means it has been given a statutory right. So all the sectors, regardless of the type of employment, the minimum wages have to be fixed by the appropriate government. There is also timely payment of wages. Payment has to be made in time. The time has been fixed, which is also a progressive legislation, and the introduction of national floor wage. Now what happens is that state government defines the minimum wage for the state sphere, central government in the selected central sphere. What is happening is that there is a large scale regional difference in the minimum wages across the country. So that has been taken into consideration, and in the labor codes, central government will define a national floor wage. It will not be single wage. It will obviously based on the regions. It will vary from region to region, but the magnitude of difference that was there in the minimum wages across the country will substantially be reduced. For the women, as I said, there should not be any discrimination on the basis of gender in payment of wage. If similar work is being done by male and female, then similar payment, similar wage payment has to be made. Universalization of safety standards. Again, safety standards, central government was defining only for 7 sectors. Now it has been made universal. This safety standard will be centrally or will be defined by the central government, which all the states have to follow. So that it will be a universal safety standards across the sectors and across the country. Formalization of labor, wherein the employers are expected to issue mandatory appointment letters. This will lead, because the appointment letters will define what kind of labor he is, what is the duration of his engagement, what kind of minimum wage or whatever his wage he would be getting. All these would be given in the appointment letter, which will lead to formalization. We are a country having one of the largest working population in the unorganized sector. This will lead to formalization of the labor force. Fixed term employment provision have been given in the IR code, also in the social security code. This will reduce contractualization. There are provisions for skill development. If the workers are retrenched, then there will be reskilling fund which the employers have to fund for. That would be around 15 days wage of last run, which will be credited to the account of the retrenched workers, which will be used for reskilling of that particular worker to increase his employability. No discrimination on the basis of sex in recruitment. There should not be any discrimination. Then 1/3 members in central or state advisory boards, as I was mentioning, their voice in wage fixation. If minimum wage is fixed by the wage board, which is an advisory board, and proportional representation of women would be there. That means in the policy decisions of the country, women will have direct say. Similarly, advisory boards and other boards, they have a professional representations. Fixed term employment, this was a lot of there is a lot of demand from various stakeholders to introduce this. This has been made as part of statute now. Gratuity for fixed term employment will be given if even he completes only 1 year. In case of permanent employees, it is 5 years. So that is also one of the labor friendly provision in the IR code. Retracement of workers with at least 1 year of continuous service, they have these facilities: 1 month's notice before termination and 1 month's wages in place of notice. These provisions are given in the IR code. Then reskilling fund, I was mentioning on that, 15 days of wages will be given to the retrenched worker. Expansion of definition of a worker, like journalists, supervisors getting 18,000 or less, because this 18,000 limit will be subsequently revised by the government, but under the statute it has been brought under the definition of worker. Then digital artists and stunt persons. For the movies, film industries, the heroes act, but actually stunt persons are different, which we do not see. Those are very risk prone. They undergo a lot of risks and injuries, and they were not been taken care properly. So that is why they have been brought under the definition of worker and the courts. For women, under the IR code, if the women have completed, the women worker have completed their maternity leave, then if the employer agrees, they can also work from home. Not just for women, but also for other sectors. That facility, remote work facility, all these have been given in the labor codes as well. Then there are internal complaint communities like any other establishment. That facility is also there. OSS rules defines about the ICCs and the various provisions under them. The employees compensation. The most important provisions under this is that if you are commuting house to work and workspace to back to house, during commuting, if the accident occurs, this will also employee compensation will cover that. Gratuity and provision same almost. What was there in the previous acts. Unorganized workers social security fund will be there. Then social security fund will be there for the gig and platform workers. I mentioned there are defined social security schemes which will be run by the ministries and appropriate government for this type of workers. These were all the labor codes are actually communicated to the audience. Thank you so much.
Introducing the Tele-law Citizen mobile app for the Indian citizens. This app has been specially developed for you as a citizen by the Department of Justice, Government of India in collaboration with CSC. Through this mobile app, you as an applicant can get free legal advice and assistance from professional panel lawyers of the country in all kinds of disputed matters. Download the Tele-law Citizen mobile app today